Welcome to Trust Me, It's Complicated, the podcast where we take complex estate planning issues and break them down to make it easier to understand and follow. Because you know what? I don't understand what you do. You probably don't understand what I do. Well, let's break down those barriers and let's start talking about some of these things here today. So today's podcast, we're going to focus on the five biggest estate planning myths that exist that cost families thousands. And I don't mean just a couple of thousand, I mean tens of thousands of dollars. I've seen families where things were done based upon a belief in something that actually wasn't true that cost them 30, 40, $50,000. Sometimes we can fix things after the fact. Sometimes we can't. And even if we can fix it, it's going to be more expensive than if we had planned appropriately up front. So let's talk about these myths. Let's put some of these things to bed so that when you move forward after this podcast, you can say, hey, you know what? I'm going to do things right. And you don't get caught in a situation where your estate is losing money after you're dead, or even while you're alive, we don't run into issues that is going to take money out of your pocket at a time that you need it to live on. In bank accounts, wife dies, husband's not on the account. She did not have an estate plan saying where it's going. Well, in that circumstance, once again, we have to look at, are there children? Are there children from prior relationships? Let's say, again, wife has children from prior relationship. She dies. Husband gets one half of that account. The children get the other half of that account. He does not get it all. So, again, this is where I tell people you've got to be very careful with the assumption that, hey, I'm married, therefore my wife or my husband gets everything. They don't, because we have so many different things that we have to run down. Like I said, what is the nature of the asset? Who are basically the parties involved? Spouse, yes. Are there children from other relationships, things like that? Again, we have to determine that. Are there minor children? I mean, you start getting into homestead property and then you throw minor children into the mix, we've got even more issues to address. And, we actually have flow charts that we will refer to, and we'll look at the nature of the asset and go, okay, husband survived wife. Do they have children? Yes or no? Do they have children from prior relationships? Yes or no? And again, it breaks it down. When it comes to homestead property, it's not just a couple of steps. It's like 10 steps figuring out how that property is going to pass on. Now, let's go back to the homestead property, and let's say husband has a life estate, kids have the remainder interest. They could jointly agree to sell. Husband gets paid a value for his life estate, kids get a remainder interest. But then does husband have enough money to buy his own home? Again, there's a lot of ifs, ands, or buts. And I will say that there was a law passed in Florida, it's been a while now, but the law says you can elect as a surviving spouse to take a half ownership in the property versus a life estate. And, we have to sit down and run the numbers and figure out, is that advantageous or not? Okay. But that is an option, but you only have 6 months from the date of death, not 6 months from when probate is opened, 6 months from the date of death. So in that example I gave earlier where wife died, husband's living in the property, his name's not on the deed, she has kids from a prior relationship, they never talked, the husband didn't talk to us until around a year after wife died, and there were people looking to get paid, and they're now coming after him. Well, he's not responsible for her debts. So now they're looking at anything she owned. And without getting into the fact that homestead property is a protected asset, meaning creditors can't come after it, they're trying to. And yet now the husband finds out, what do you mean I can't sell the home? Well, that's not the time to find out. The time to address it is now. Okay. So you've got to put aside this idea that I die, my spouse gets everything. Yeah, that's just not true. So the best plan is to say, hey, we do an estate plan and I'm going to leave my spouse this much, or I'm going to give them this asset, things like that. Um, so, again, don't put it all like they did. Beneficiaries are people identified in a will or a trust, people you pick. Heirs are the people that the state says, these are the people who get the stuff if you haven't picked. So, bottom line is, on this myth, estate planning is only for the wealthy. You could have $100,000 estate, and your family could be looking at a $5,000 to $10,000 probate bill, because not only is it costly from a standpoint of legal fees and different things like that. We've got expenses, court expenses, publication fees, but it's also from the standpoint of having to address creditor claims, but it's also the time it takes to make distribution of assets. If an estate has more than $75,000 in assets, it can take anywhere from 9 months to a year to complete probate. Under 75,000, we hope that we can get distribution done in 4 to 6 months. The sad reality is we are starting to encounter situations where even summary probate is taking longer. And here's where it gets really frustrating. I've been doing probate now for 20 years. I like probate. I like helping families in this area. One of the reasons that I do a lot of probate work is in my probate cases, I am looking for things that other people did badly that caused them to end up in probate, so that in my estate planning practice, we don't repeat those mistakes. Okay. Now, estate planning is for the wealthy? No. Estate planning is for anyone who has assets that they clearly want to pass to the right people in an efficient manner. Now, this is where when somebody comes to me and they say, oh, my neighbor told me I have to have a trust. Maybe, maybe not. Maybe a will will work fine for you. Maybe we can do something like an enhanced life estate deed called a ladybird deed. Maybe we can do a beneficiary designation, which again, I'm not big on using beneficiary designations at a bank or with your financial advisor on your IRA, stuff like that, unless it's done in conjunction with an estate plan, because Murphy's Law, which says if it can go wrong, it will go wrong, is very, very real. And so I tell people I like using beneficiary designations as part of a coordinated estate plan. So when people are looking at the fact that they have assets that they want to get transferred from them to other people at death, well, those assets are important. 100,000 is as equally important as 1,000,000. So the idea that you have to be wealthy to have an estate planning issue is not really the case. Or I have to be wealthy before the costs are significant. Really not true. And the sad reality is, in this day and age, it almost feels like the smaller estates are just as costly and time consuming and expensive as the very large estates. Handling $1,000,000 is almost no different than handling 100,000. You still have to go through formal probate. You still have to meet all the different judiciary requirements, which are really, really starting to mount. And we'll talk about that here in a second. But what we end up facing is the fact that the costs are for 1,000,000 are about the same as for 100,000. But when you look at a percentage, the percentage of how much you lose in a $100,000 estate is not the same percentage as you lose in a $1,000,000 estate.